Section we're going to cover is AIA contracts. And just like the accounting, AIA contracts assume that you understand contract law. So first of all, you've got to get the big picture on contract law. Then we come back to the AIA contracts. Some of the contracts we have that you're going to need to know is the A201 AIA contract. You're going to need that one. The 401 contract. The 701 contract. The application for payment. This is one you're going to like a lot. This is your application for payment. And this is your release of lien. Whenever you finish a job, you need to give somebody a release of lien when they pay you off, so that you're guaranteeing them that no one can come back and sue them for money. So you're going to need the release of lien. This is very important. When anything changes, you get a change order. Get it in writing, get it signed. Because while you're doing the job, they'll agree to anything. When the job's over, not going to want to pay for it. All change orders need to be in writing. Okay, these are your AIA contracts that you need to be familiar with. You need to know these little books backwards, forwards, sideways. They're going to ask you about 28 questions out of this. That's nearly 25% of all the questions you're going to answer on the second half of the first day and the first half of the second day are going to come out of these little booklets right here. All right, we're gonna cover contract law. This is the big picture. It's sort of the background information you're required to know so that you can understand the AIA contracts. So, contract law, we have the essentials of an offer. An offer must be communicated to the offeree. Both parties must manifest an intent to agree. The offer must be explicit. Essential elements of a contract: there must be mutual consent, consideration, legality, and capacity. Types of a contract: you have express contracts. All parties to the contract have manifested their agreement orally or in writing. You have implied contracts. A contract can be discerned by the actions of both parties, but has not been put into words. You have bilateral contracts. Two types of contracts. One is bilateral. Is a contract in which both parties exchange promises to do something. These are considered and contracts. You do this and I will do that. Then you have the unilateral contract. This is a one-way contract. This is one where the parties make an offer to the other party, but the second party is not obliged to take the offer. These are if-then contracts. If you do this, then I will do that. An executed contract: all parties to the contract have performed on their promises. An executory contract is one that is yet to be performed. One or more parties to the contract have made one or more promises as yet to perform. Revoking an offer: a bilateral contract can be revoked any time before the offer is accepted. A unilateral offer cannot be revoked for a reasonable amount of time once the party has begun to work or perform on the contract. Statute of Frauds: certain types of contracts must be in writing. Contracts for over $500 must be in writing. Contracts that transfer real property, real estate. Contracts for more than 1 year must be in writing. A valid contract: a valid contract is one that meets the three requirements of a contract. A void contract is one that does not meet the three requirements of a contract. Bids: bids are not contracts. The bid is an offer. Okay? A bid is generally good for 30 days unless a different time period is defined. Acceptance of the bid must be clear, must be obvious. Acceptance of bids: a bid must be accepted as is with no modifications. Any changes to a bid constitutes a counteroffer. Bid shopping: bid shopping is common. Bid shopping is illegal on government contracts. To stop bid shopping, a provision of the bid can state that the use of the bid to obtain other bids constitutes acceptance of the bid. You can try it, probably won't work, but this is what is suggested in the contractor's manual, and I'll pull that out in a minute. The AIA Forms, as I've already stated, You have the AIA 101, which is the stipulated sum agreement. You have AIA 201, which is general conditions of the contract. What this is between the owner and the builder. 401 is between the contractor and subcontractor. 701 is instructions to bidders. It tells them what they have to do and the time schedules for performing on the bid. G701 is your change order. G706 is a release of lien. And the G702 is an application for payment. You either want to have these handy with you, you need to have these on the exam with you, but they might ask you something like, what is a G702 used for? Or what does the G706 do? The AIA 201 contract is your main contract. It's the owner-contractor agreement. And it calls for the successful bidder to submit a list of subcontractors for approval. Okay. So we're going to go down through 14 sections that are covered in Walker's. The AIA 201 defines the documents, the work that's to be done, the project, the correlation, the intent, and the interpretations of the contract. So this section 1 defines the overall content of what you're going to do and what the intent of this contract is. Section 2 of the contract defines the architect as the administrator. In other words, he's sort of like the referee between the owner and the builder. Section 3 defines the owner, who the owner is, and what the owner's rights and responsibilities are within this contract. Section 4 defines the contractor, who he is, his duties, what he needs to supervise, the nature of the construction, and all the labor and materials that he's going to be required to provide. It defines any warranties he's going to provide, as well as the taxes, permits, fees, notices, cash allowances, progress schedules, and drawings that must be kept on the job site. So it defines what the job's going to be and how he or she is supposed to do it. Section 5 defines the subcontractors, who they are, how they're supposed to be hired and dealt with, and how they're supposed to be controlled by the contractor. Section 6 sets forth the owner's rights. Section 7 are miscellaneous provisions. Section 8 defines the contract time. Section 9 discusses payments and completion sums. Section 10 covers protection of persons and property. Section 11, insurance requirements for the job, what insurance you're required to have and any bonding. 12 includes change orders, how change orders are to be dealt with within this contract, what you have to do to get a valid change order. 13, acceptance of defective and non-conforming work. What if something happens and it's not according to the specifications? Well, that's what Section 13 says. How do we deal with defective work and how do we deal with non-conforming work? Section 14 is termination of the contract. If something goes wrong with either party, what are the rules we play under in order to terminate this contract? Okay, and so that's the basic overview of AIA 201. AIA 201 is sort of like your master document that you're dealing with. This is between the contractor and the property owner, the person you're building from. And the architect is considered to be the referee, so that if there are any points of confusion, you go to the architect, you ask him, okay, clarify this. If anything goes wrong, typically the architect works as the arbitrator. On the AIA contracts, there are sections in these contracts that come up on almost every exam anybody takes. In other words, there's core information that they just expect you to know. Okay, so we're going to go down through that. It may not make sense to you until you've read the contracts yourself, and then you'll say, okay, I get it. But I'm just going to go through and review parts of the contract that come up regularly, okay, in the exam questions. Okay, such as Section 1.6, ownership and use of the drawing specifications, other services. The contractor may keep one set of drawings for his records, but the architect shall remain all rights to the drawings, and all other copies of the instruments, drawings, and specifications shall be returned to the architect. So what they're saying is the architect who drew this, put the whole project together, the drawings and specifications are his. They don't pass to the owner or to the contractor, and the contractor is supposed to give him back everything except he can keep one copy for his records. Section 223, the owner shall furnish surveys describing the physical characteristics, legal limitations, and utility locations for the site of the project, and a legal description of the site. So this is what the owner of the property has to give to the contractor. Has to furnish him with surveys, legal limitations, utility locations, and a legal description of the site. 2.41, owner's rights to carry out the work. If the contractor defaults or neglects to carry out the work in accordance with the contract documents and fails within 7-day period after receipt of written notice from the owner to commence and continue correction of such default or neglect within diligence and promptness, the owner may, after such 7-day period, give the contractor a second written notice to correct such deficiencies within a 3-day period. If the contractor, within a 3-day period after receipt of such second notice, fails to commence and continue to correct any deficiencies, the owner may, without prejudice to any other remedies to the owner, correct such deficiencies. The owner can come in and start making repairs to the contract site if they have given the contractor proper notice. Section 321, if a contractor discovers any errors, inconsistencies, or omissions discovered by the contractor, shall promptly report these to the architect as a request for information in such a form as the architect may require. So if you find anything wrong on the project, you're required to bring it to the attention of the architect. 332, the contractor shall be responsible to the owner for acts and omissions of the contractor's employees, subcontractors, and their agents and employees, and other persons or entities performing portions of the work for or on behalf of the contractor or any of his subcontractors. So in other words, whatever happens on that job site, the contractor is responsible for it. You can't say, oh, subcontractor messed up. Doesn't matter, contractor is still responsible. 343, the contractor shall enforce strict discipline and good order among the contractor's employees and subcontractors. 3.7.1, permits and fees. The contractor shall secure and pay for the building permit and other permits and governmental fees, licenses, and inspections necessary for proper execution and completion of the work, which are customarily secured after execution of a contract. That's a question that comes up continually. Who has to pay building permits, governmental fees, licenses, and inspections? 3.73, it is not the contractor's responsibility to ascertain that the contract documents are in accordance with applicable laws, statutes, ordinances, building codes, and rules and regulations. That's the architect's job. 3.81, allowances. Allowances comes up quite often on the exam. The contractor shall include in the contract sum all allowances stated in the contract documents. Items covered by allowances shall be supplied for such amounts and by such persons or entities as the owner may direct. 3.11.1, documents and samples at the site. The contractor shall maintain at the site for the owner one record copy of the drawings, specifications, addenda, change orders, and other modifications in good order and marked currently to record field changes and selections made during construction. One record copy of approved shop drawings, product data, samples, and similar required submittals shall also be on the property. 3.12.1, shop drawings. Shop drawings are drawings, designs, schedules, and other data specifically prepared for the work by the contractor or a subcontractor or a subcontractor, manufacturer, supplier, or distributor to illustrate some portion of the work. Typical question, who can do shop drawings? Boom, you come to 3.12.1 and it defines who can do shop drawings. 3.12.7, the contractor shall perform no portion of the work for which the contract documents require submittal and review of shop drawings, product data, samples, or similar submittals until the respective submittals have been approved by the architect. 3.12.8, the work shall be in accordance with approved submittals, except that the contractor shall not be relieved of responsibility for deviations from requirements of the contract documents by the architect's approval of shop drawings, product data, samples, or similar submittals unless the contractor has specifically informed the architect in writing of such deviation at the time of submittal. 3.13.1, the contractor shall confine operations at the site to areas permitted by law, ordinances, permits, and the contract documents, and shall not unnecessarily encumber the site with materials or equipment. 9.3.2, unless otherwise provided in the contract documents, payment shall be made on account of materials and equipment delivered and suitably stored at the site for the subsequent incorporation into the work. 9.3.3, the contractor warrants that the title to all work covered by an application for payment will pass to the owner no later than the time of payment. The work will be free and clear of liens, claims, security, interest, or encumbrances in favor of the contractor, subcontractor, material supplier, or other persons. That's about the end of AIA 201. You need to read through it continually, get to know this little document backwards and forwards, and highlight all these sections that I've written down here. They're going to ask you, like I said, about 28 questions out of these little books. So the better you know your AIA contracts, you can pick up 28 questions out of here. AIA document A401, standard agreement form between the contractor and the subcontractor. Let's review some of the important elements of this. The 401 document, as I said, is between the contractor and the subcontractor contract agreement. The important element is that the final payment shall be due when the work is completed satisfactorily to the architect and the owner, not just to the contractor. You have to make sure the architect and the owner are happy with the subcontractor's work. The subcontractor shall not assign or subcontract the work without the written consent of the contractor. So a subcontractor cannot hire subcontractors without first getting a written consent to do so. Subcontractor shall report to the contractor within 3 days the injury of any of the subcontractor's employees on the site. You've got 3 days to report any injuries. If a subcontractor is not paid by the contractor through no fault of the subcontractor within 7 days of the time in which the payment should have been made, the subcontractor may give 7 days written notice to the contractor to stop work until the amount has been paid. So the contractor can stop work after 14 days, 7 days plus 7 days. Unless otherwise provided in the contract document, the contractor shall pay the subcontractor each progress payment and the final payment under the subcontract within 3 working days after the contractor receives any payment from the owner. Back charges. If the subcontractor defaults or neglects to carry out the work in accordance with this agreement, or fails within 7 days of receiving a written notice from the contractor to commence or continue corrections of such default or neglect with diligence and promptness, the contractor may, after giving 7 days from receipt by the subcontractor of any written notice and without prejudice to any other remedy, he may have such deficiencies made good and may deduct the cost of those repairs from the money owed to the subcontractor. In these contracts, time is considered to be of the essence. Within 30 days of the architect issuing a certificate for payment covering the substantially completed work, the contractor shall, within the extent of the documents, make payments to the subcontractor the entire unpaid balance of the contract sum, or of that portion of the contract sum contributable to the substantially completed work. After a payment is due the subcontractor is entitled to the payment plus interest. So if a subcontractor doesn't get paid in time, he's entitled to the money's due plus interest. Before issuance of a payment to the subcontractor by the contractor, the subcontractor shall be required to submit evidence of all bills having been paid. So he's going to need waivers of liens or paid receipts. The subcontractor's ability to assign his portion of the subcontract is permissible within written consent from the contractor. Permit for subcontractor shall be the responsibility of the subcontractor for payment. So any subcontractor permits that are required to be pulled, such as plumbing, the subcontractor is going to have to pull them. Air conditioning, plumbing, stuff like that. The contractor shall provide the subcontractor with a copy of the estimated progress schedule of the entire project job, so he knows when his work's supposed to be done. Contractor shall notify the subcontractor of all modifications of the contract promptly. If the work is stopped for a period of 60 days through no fault of the subcontractor, because the contractor has not made a payment to the subcontractor may, in writing, give 7 additional days' notice and then terminate this contract. The subcontractor agrees that all aesthetic work shall be done subject to the final approval of the architect.